Can my employer fire me over social media posts? Imagine this. You post something on Facebook, Instagram, or Twitter after a long day. Maybe it's a meme about your boss, a heated opinion about politics, or a simple complaint about your hours. The next day, your manager calls you in and says, "We saw your post, you're fired." Just like that, your job is gone because of something you said online. It feels unfair. And the first question is, can my employer really fire me over social media posts? This question matters because social media has blurred the line between work and personal life. Millions of American workers share thoughts online every day, but not all posts are treated equally under the law. Some posts are legally protected, others can get you terminated. In this video, we'll break it all down. What at-will employment means when social media speech is protected, what posts put your job at risk, and what workers can do if they're punished for posting online. At-will employment and the First Amendment myth. The foundation of U.S. employment law is at-will employment. That means most private sector workers can be fired at any time, for almost any reason, or for no reason at all. Social media is no exception. If your employer sees a post they dislike, they can often terminate you. Here's the myth. Many workers think the First Amendment protects them. In reality, the First Amendment limits government restrictions on speech. It does not restrict private employers. That means if you work at a private company, your free speech rights don't stop your boss from firing you over a Facebook post. Example. A retail worker posts political opinions online. The employer disagrees and fires him. That's legal under at-will rules because the First Amendment doesn't apply to private workplaces. Where speech becomes protected, the NLRA. Not every post is unprotected. The National Labor Relations Act, NLRA, protects concerted activity when workers act together to improve wages, hours, or working conditions. That protection can extend to social media. Example. A group of fast food workers posts on Facebook about unsafe kitchen conditions and low pay. If management fires them, that's likely illegal retaliation under the NLRA, but protections are limited. Posts must involve group concerns about workplace issues. Personal rants, insults, or off-topic posts are not protected. Example. A worker calls his boss a jerk on Twitter with no mention of conditions. That's not protected, and firing is legal. Discrimination and retaliation laws still apply. Even if employers have broad power, they cannot use social media as a disguise for discrimination. Federal laws still apply. Title VII of the Civil Rights Act protects workers from being fired because of race, color, religion, sex, or national origin. ADA protects workers with disabilities. ADEA protects workers age 40 and older. Pregnancy Discrimination Act bars firing for pregnancy-related reasons. Example. A Muslim worker posts about celebrating Ramadan. A week later, she's terminated. If the employer claims it was about the post, investigators may see it as religious discrimination under Title VII. Retaliation protections also apply. Workers cannot be fired for posting about wage violations, protected by the FLSA, unsafe conditions, covered by OSHA, discrimination complaints, investigated by the EEOC, union organizing, protected by the NLRA. Example. A warehouse employee tweets about unsafe machinery and tags OSHA. A week later, he's fired. That timing suggests retaliation, which is unlawful. When employers can fire over posts. Employers still have wide latitude to act when posts. Harass or threaten coworkers. Reveal confidential information. Damage company reputation. Create a hostile work environment. Under Title VII, employers must prevent harassment. If your post includes racist, sexist, or offensive jokes, firing is often lawful. Example: an employee posts slurs online that coworkers see. Management terminates him. That's legal because employers must stop harassment. Employers can also fire workers for leaking trade secrets, patient data under HIPAA, or private business information. Example: a hospital employee shares confidential patient details in a Facebook group. Firing is legal under privacy laws. State laws on off-duty conduct. Some states provide more protections for lawful off-duty conduct, including online activity. California and New York protect workers from being fired for lawful political activity outside work. Colorado bars firing for lawful off-duty conduct unless it directly impacts business. North Dakota broadly shields lawful off-duty activity. Example: a California worker posts about attending a political rally. If she's fired, she may claim protection under state law. But even in these states, protections are not unlimited. If posts directly harm the employer's interests, such as revealing trade secrets, termination may still be lawful. Real-world cases expanded. Case 1. NLRB. Decision. In 2012, nonprofit employees posted complaints about their supervisor on Facebook. The NLRB ruled it was protected concerted activity because they discussed workplace conditions. Case 2. Teacher tweets. A teacher posted controversial political tweets. Courts upheld her firing, finding her speech disrupted the workplace and wasn't protected. Case 3. HIPAA violation. A nurse posted patient details online. Termination was upheld because privacy laws were violated. Case 4. Colorado political speech. A worker posted about politics and was fired. The state ruled in her favor under Colorado's off-duty conduct law. These examples show the line between legal and illegal terminations depends on context. Employer monitoring and privacy. Public posts are fair game for employers. Private posts are harder. Many states prohibit employers from demanding social media passwords. But coworkers can screenshot posts and bring them to management. Once a post enters the workplace, it can become grounds for discipline. Example: an employee vents in a private group. A coworker shares it with HR. The employer fires him. Depending on the content, that's often legal. Practical steps for workers. 1. Pause before posting. If it relates to working conditions, it may be protected. If it's insults or harassment, it's not. 2. Check your state laws. California, Colorado, and New York provide added protection. 3. Know your rights. Posts about wages, hours, or unsafe conditions may be protected under the NLRA, OSHA, or the FLSA. 4. Document retaliation. If you're fired after posting about safety or discrimination, keep evidence. 5. Seek legal advice. Agencies like the EEOC or OSHA can investigate retaliation claims. Example: a barista posts about unpaid overtime. She's fired. With legal help, she proves retaliation under the FLSA and wins back pay. The human impact. For workers, being fired over social media feels like being punished for private life. People vent online, share personal experiences, and connect with friends. Losing a job over a post is a harsh reminder that online speech carries real-world consequences. Employers argue they must protect reputation and workplace culture. Workers argue they deserve freedom outside of work. The law struggles to balance these interests. The bigger picture. Social media has blurred boundaries between personal and professional life. At-will employment gives employers broad power, but federal law carves out protections for concerted activity, discrimination, and retaliation. State laws expand protections in some places. Still, in most of the country, workers must assume employers are watching, and posts can affect employment. So, can your employer fire you over social media posts? In many cases, yes. At-will employment gives employers wide discretion, and the First Amendment doesn't shield private employees. Posts involving harassment, threats, or confidential information almost always justify termination. But not all posts are unprotected. The NLRA shields discussions about wages and working conditions. Title VII, the ADA, and other laws prohibit using posts as excuses for discrimination, and some states protect lawful off-duty speech. The bottom line, online speech can affect your job. Before you post, know where the legal lines are, and if you're fired for protected activity, you may have the right to fight back. If this video helped you understand, share it with coworkers, because in today's world, protecting your rights online is part of protecting your rights at work.